Welcome, everyone. Thank you for joining us for our online conversation on California Living Trust Basics. I'm Kimberly Mueller, Director of Major and Planned Gifts at the San Diego Public Library Foundation, and I'll be your host. I'm excited about our talk today with Jennifer McGibbons, who will be introduced shortly. There's been a lot of interest in our estate planning webinar series. People are looking for estate planning education to make informed decisions and looking for a trusted guide. The Library Foundation is a resource in their estate planning process. You can visit our previous estate planning webinars by visiting this link in the chat. First, a little housekeeping. We will be recording this talk and will make it available to you. I encourage your comments in the chat box. There's a Q&A button below just for questions for our speaker. We'll have a Q&A discussion toward the end of the program. Keep an eye on the chat, as we'll also be providing valuable links. We've created a handy planned giving guide for simple ways to make a gift and a lasting impact in your community. There's a link for it in the chat. You can click on it right now, and we'll also be emailing it to you. And just a reminder that our events and materials are for informational purposes only. They're not intended as tax or legal advice, so please consult with your own qualified professional advisors. Now, before we begin, I'd love for you to hear from Patrick Stewart, CEO of the Library Foundation. Patrick?
Kimberly, thank you and good afternoon. My name is Patrick Stewart, and I serve as the CEO of the Library Foundation. And I want to say that we are so grateful for all the support from each of the organizations that we recognized at the start of this program. I'd also like to recognize and thank the current and former trustees of the Library Foundation. And if you are a current or former trustee with us this afternoon, please say a quick hi in the chat so that we can all recognize you. And again, on behalf of the Foundation's board, staff, and its volunteers, welcome to this afternoon's webinar. We're really glad to have you join us. The Library Foundation plays an important role in serving San Diego in that our mission is to strengthen our communities by supporting excellence in the San Diego Public Library system through philanthropy, advocacy, and outreach. The Library Foundation is a catalyst for creating stronger communities through investment in the San Diego Public Library system, where access to resources supporting literacy, workforce readiness, and lifelong learning ensure equal opportunities for success. We do this through building lasting relationships with our philanthropic and corporate communities, through ensuring that our elected officials prioritize the value that the library has in every San Diego community, and in creating effective channels that convey that impact. The Library Foundation ensures that our library system has the tools and the resources it needs to fulfill its vision every single day through the generosity of supporters just like you. This year, through your support, the Foundation has been able to support and assist the library in reopening branches, expanding education opportunities to children and adult learners alike, bridging digital divide issues, and providing vital resources to entrepreneurs to start or grow their businesses. The library is an essential tool in the city's ability to support job seekers and economic recovery as San Diego prepares its post-pandemic life. The Foundation is committed to prioritize our support through your generosity to this assistance. Additionally, in partnership with the library, the Foundation has spent this year supporting the very important work of the development of a new library master plan. Designed to build on the innovative and forward-thinking work of the library system, this new plan will more accurately take into account library usage on a community-by-community basis, ensure that it is on pace with city growth, and that the library is able to deliver its programs both on-site, incorporate cutting-edge technology, and is able to continue to meet community needs in a proactive, impactful manner. Paramount to the development of this current phase has been community engagement and involvement. Nearly 8,000 fellow San Diegans have lent their voice through a comprehensive community survey, a series of focus groups, participation in 2 virtual draft presentations, and by providing public feedback on the current draft. The draft has been presented positive reception to the City Council's Public Safety and Livable Neighborhoods Committee. And while our intention is to present the final draft of this framework document to the Library Commission on November 3rd, there's still time to contribute your thoughts through the public comment section on the library's master plan webpage. On that page, you'll be able to watch the introductory video, read the full report, and share comments and input on the plan. The link to that page is in the chat. Again, thank you. Thank you for your support of our library, the Library Foundation, and thank you for your interest today in how your support for the causes you value most can be provided for years to come. And with that, I'll turn over to Kimberly so that we can get started.
Thank you, Patrick. I chat with Library Foundation donors every day, and when I ask them what inspires them to give, they talk about how important the library was to them as a child and how essential it is for them now. They talk about reading books and using the technology. They talk about free access for all and education and equity. They tell me about what matters to them and what they want to see live on. Many of them have made planned gifts to the Library Foundation. For those of you who have, many thanks to you. We encourage you to advise us of your intentions so we can honor your wishes. We invite you to join our Carnegie Society so that we can thank you and you can be part of this community of supporters. We have it in the link in the chat. Members are invited to have their name added to the Carnegie Society wall, which also inspires others, and they enjoy events and benefits throughout the year. I'm honored to highlight Carnegie Society members Randy Dropkin and Phyllis Charlton. Randy and Phyllis have been loyal supporters over the years. They've made a gift to the Library Foundation in their trust and have also made us a contingent beneficiary of their retirement plans. We appreciate the care they've taken in letting us know. I asked Randy what inspired their estate gift, and she shared with me how happy they are to be library supporters. The library has always been an important part of Randy's life. She has fond memories of growing up. On Saturday mornings, her family would check out a week's worth of books. As a former teacher, she always used the library resources and stressed their value to her elementary age students. Once retired, she had a goal to visit all 36 branches, checking them off as she visited them. She loved seeing what made each neighborhood branch unique. She said that libraries are hidden gems with so many resources and all free. Anyone is welcome. By including the Library Foundation in their estate plans, Randy and Phyllis are helping the library continue to be a vital place of free access and lifelong learning. Please visit our website to read the stories of donors who are using their estates to make an impact in the community. We have it in the chat. I'd like to bring in Natalie Gans now. Natalie is the Library Foundation's Chief Strategy and Engagement Officer, and she has over 10 years of plan giving expertise. She'll be introducing our speaker and monitoring your questions. Natalie, would you like to join us?
Thank you, Kimberly. I am so pleased to be able to introduce our speaker to you today. Jennifer McGibbons is a founding partner of Sullivan, McGibbons, Crickard Associates, LLP. Her practice is focused in the areas of estate planning, trust and estate administration, probate, and charitable planning. She has extensive experience in estate planning for individuals and families, including trust formation, charitable giving, transfer tax planning, incapacity planning, intra-family transactions, and trust and probate administrations. Prior to forming Sullivan, McGibbons, Crickard Associates, she was a partner at Henderson, Caverly, Pum, and Charney, and an associate at Luce Forward, Hamilton, and Scripps. She earned her Juris Doctorate at the University of San Diego School of Law and her bachelor's degree at Cornell University. She is a certified specialist in estate planning, trust, and probate law, and she's also part of the North County Estate Planning Council. She has many accolades, including as a California super lawyer and being listed AV Preeminent from the Martindale Hubbell. In the community, she's been involved at Scripps Health, the Rancho Santa Fe Foundation, Rady Children's Hospital Foundation, and the Rancho Santa Fe Literary Society. Jennifer, thank you so much for being with us today.
Well, thank you so much, Natalie, for the introduction. And it's such a pleasure to be here speaking to all of you this afternoon albeit remotely. So as Natalie noted, I am an estate planning attorney here in San Diego. I've been practicing in this area since 2002. And it's such an amazing and interesting area of the law because it's very practical and really applies to everyone. I will talk to clients with a lot of frequency about whether or not they even need an estate plan. And I will immediately correct them and say everyone needs an estate plan, regardless of the size of their estate. And it's really just what documents are included in that plan that really is the difference when I'm talking to clients. So today, I have the pleasure of talking to you about California Living Trusts and whether or not you need one. So I always start my initial consultations with clients, giving them a general overview of what is a living trust, the difference between a trust and a will, and whether or not they even need one. So I want to start with what is a trust? And you have that first slide up on your monitor. A living trust is a document created by an individual or individuals to manage his or her assets while that individual is living, and then confirm who's going to receive those assets at that individual's death. This type of trust is revocable and amendable. So I talk a lot with clients about everything we're putting in place when we put together a living trust can be changed over time and should be changed over time. It does not provide creditor protection for my clients. I get that question a lot. If I set up a living trust, all my assets are protected from creditors. That's not the case. This type of trust still belongs to you. There's no separate tax identification number. The tax ID number for your revocable living trust is your social security number. All of the income is still reported on your personal income tax return. So this vehicle is really geared towards easing your administration when you pass away, and also dealing with how things are going to be handled in the event of incapacity. This trust is different from an irrevocable trust or a gift trust. There's oftentimes a great deal of confusion between the different types of trust, but for purposes of today, we're talking about a California revocable living trust. So I wanted to move on now to a couple of key terms or definitions whenever we're talking about trusts. The first one is going to be settlor, trustor, or grantor. They're kind of all used interchangeably, but this person is the individual who's creating the trust and transferring their assets to the trust. Here in California, we do allow joint trusts, typically with spouses. So we can sometimes see trusts that are created by multiple people, but the settlor or trustor is the one creating the trust. Trustee, that's another commonly used term. The trustee is the person or persons holding, managing, and distributing the assets based on the terms of the trust. And then the third term that we're going to talk about is beneficiary. So a trustor is going to create a trust, move assets into the trust that are going to be managed by the trustee for the benefit of an individual. So all the income and principal based on the terms of the trust will be distributed for the benefit of one or more individuals. Whenever we're setting up California Living Trusts, all three of those roles tend to be taken by the same person. So I would be creating a California Living Trust. I'm going to be the settlor or the grantor or the trustor. I'm going to be the trustee. So I'm going to be the one managing and distributing the assets. I'm also going to be the beneficiary. So as assets are distributed out, they belong to me and they will go for my benefit. I talk to a lot of clients about, if I create a trust, Jennifer, is my control or my management of these assets going to suddenly change? And the answer is no. These assets in this trust are yours still. We're just simply trying to ease the process in the event something happens to you. And so it is not a document that will suddenly change your ability to manage your assets and your affairs. I will sometimes have clients who come to me and say, I'm involved in this one transaction, Jennifer. They need to see this special language in my trust in order for me to buy this business or sell this business or refinance this asset. And in that scenario, I say, that's great. Just let me know what language they need to see in that trust, and we put it in there. So again, we're not tying the hands of the client whatsoever. We're trying to set forth what they want done while they're alive and what they want done at death. Okay, and as noted at the bottom of the slide, a living trust is a substitute for a will. So I'm going to move to the next slide. So that leads me to what is the difference between a living trust and a will? And why do we here in California tend to see trusts more frequently? So every state here in the United States has a very different process when a person dies and how their assets are distributed out. California, perhaps not surprising to many of you, is very complicated. And so the process here in California, known as a probate administration, is time consuming, it can be costly, and it's very involved. And so people here in California, unlike other states in the US, examples are Pennsylvania, Vermont, Colorado, those states you don't see a lot of trusts because the probate administration process is very simple. Here in California, we work very hard as individuals as well as attorneys to try and avoid that formal probate administration. Probate administration is basically court regulated and supervised. You have to file a document with the court. You need to wait until you get a hearing date. There's a whole abundance of different steps you need to take to provide information to the court. And then the court at the end of the day will present, everything's wrapped up, and these are the people who are to receive your assets. By having a valid living trust in place, you avoid that entire process. So here in California, we work very hard to get that trust in place. A perfect example of how time-consuming a probate administration can be was last year when we had the beginning of the pandemic and COVID. Our court system was closed for 3 months. So any person who had a pending probate that they were trying to open or close were on hold for 3 months. I will say a simple probate administration where the assets are super simple. You maybe have one beneficiary. Beneficiary is consenting to everything, not requiring anything extra. Those administrations still take a minimum of a year to a year and a half. So it's a process that can be very delayed just based on the procedure that needs to happen, but also delayed based on circumstances in our world, for example, COVID. A living trust also avoids or provides you confidentiality. So if you have to probate a will and you're subject to a probate administration, all of those documents are a matter of public record. So anyone can go down to the court and get a copy of your will. Any fans of entertainment magazines or websites know that certain famous people, celebrities, when they pass away, their wills are published on these websites or in these magazines. Famous people such as Walt Disney, Jerry Garcia, Leona Helmsley, these are all people who their wills were subject to a probate administration. All of their personal information and distribution provisions, who got Jerry Garcia's guitars, how and when Walt Disney's wife was going to receive his assets, Leona Helmsley's $12 million gift to her dog Trouble. All of these were a matter of public record, and we all know about it. And you can go online and find all of the details about their estate plan. By having a living trust in place, though, this is a private document. So even when a third party says, hey, I need to see a copy of your trust because I need to confirm how title is held, or we need to transfer the asset into the trust, we provide them with 1 or 2 documents. One would be a certification of trust. This is a document approved by the California Probate Code that only includes certain facts about the trust. Who created the trust? That's that trustor or settlor. Who's the trustee? So who's managing and controlling the assets? When did you create the trust? How title should be held, and whether or not it's revocable or irrevocable. there are only certain things that a third party really needs to confirm. Also, what the trustee's powers are. That's really it. The third party does not need to know what your private distribution provisions are. Who's getting your car, who's getting your assets, at what age or ages your beneficiaries are receiving the assets. That can all be kept private. The other option is we provide a redacted version, or a version of the trust that removes certain private distribution provisions, so that, again, the third party can confirm what they need to in order to transfer the asset into the trust, but are not aware of your private distribution provisions. A living trust is also effective immediately. A will is not. A will we're going to sign and put in place, and hopefully it's going to be validly executed, but it really does not become effective until that person passes away. Whereas a living trust, as soon as you sign it, that is a document that is effective immediately. And so in our trust documents, we deal not only with what happens at an individual's death, how their assets are distributed, how debts, expenses, and taxes are paid. It also deals with what if I were to become incapacitated, okay? Because the document is immediately effective. It's going to include provisions saying, while I'm alive as the trustor or the settlor, I'm the beneficiary and I direct where the assets are going. But in the event I become incapacitated, my successor trustee is going to step in and manage the assets for my benefit. So it's a bit more of a comprehensive document than a will is. Also, in the event you were to become incapacitated and you only had a will in place or you had nothing in place, then a conservatorship may be required in order for some third party to come in and help you, the incapacitated person, manage your financial affairs, manage your assets. I talked a little bit about the probate process here in California, which is very complicated, time-consuming. A conservatorship process is even more so. And so we try very hard here in California in order to avoid that process. And that makes sense. The court is essentially confirming that that individual no longer has the ability to make decisions for himself or herself. And the court should take that job very strongly, because a person should be able to make decisions for themselves. And essentially that's what a conservatorship is the court is confirming this individual can no longer make personal decisions and or financial decisions. So by having a trust in place, you avoid that whole process. So there are some, I'll say, hassles involved with creating a trust. So you create a trust. The trust is only going to control what's inside the trust or funded into the trust or transferred to the trust. So when clients of mine create a trust, there is a bit of a process moving assets into the name of the trust. It's sometimes a bit more involved because we're dealing with a third party who have their own procedures in place as far as what they want to see in order to get the assets transferred over. So there is some work. My firm, we assist clients as much as we can in order to help with that. Typically, when I meet with clients, when we sign their living trust, we're going to also have the deed to their home, both primary as well as any secondary real property, ready to go and be signed at that same appointment. That is effectively transferring that asset into the trust. We record it with the county, and that's one step that's completed. But for the most part, clients of mine handle their financial assets and transferring those. So there is work involved with what are my assets? Are they appropriate? And I'm going to talk a little bit about that in a bit. To transfer into the trust. Can I transfer it into the trust? And if I can, should I? And who's going to do it? Is my attorney going to do it, or am I going to do it? So there is a bit of work. Some clients of mine push back a little bit about it, but it is really critical when you create a trust to make sure you transfer your assets over to it. And we do spend a lot of time in our meetings with clients, not only talking about their estate plan and their estate planning wishes, but also what are their assets and how can we transfer them into the trust. Okay, so let's move to the next slide. So we've talked about trusts. I've given you some basic definitions. I've explained the differences between having a trust versus a will. So now the next piece of the conversation is, does a client need a trust? And I will say, for the most part, conversations with clients, again, tend to immediately start with, do I even need a trust? My estate is relatively modest. I don't have a lot of assets. But that is really not as important as what the assets are that are owned by the beneficiary, and who are owned by the settlor or the grantor, and who those beneficiaries are going to be. And depending on the answers to those questions, a trust may make a lot of sense, even though their estate is relatively modest. They have a home and an investment account and a retirement account. Not too terribly complicated, but having an estate plan in place, having a trust in place may be necessary. So we always start with, what are the person's assets? And how do we transfer assets at death in order to avoid that probate administration? So there are certain types. Oh, let's go to the next slide quickly. Sorry about that, Charlie. Okay, so there are certain assets out there that also avoid probate like a trust does. Assets with a beneficiary designation, such as life insurance, or retirement assets, such as a 401k, traditional IRA, a Roth. Those types of assets will be distributed based on a properly executed designation. If the designation is complete, then when an individual dies, it's just going to go to the beneficiary after the beneficiary provides certain information to the third party who has custody of that asset. So if I meet with a client and all they have are retirement assets or life insurance, it's very easy to put an estate plan in place for them, and they may not need a trust structure in place. They just want to make sure that beneficiary designation is properly completed. Also, assets that are held based on joint tenancy with right of survivorship will also pass without a formal probate administration. So a lot of times I meet with spouses, and spouses own property as joint tenants with right of survivorship, or community property with right of survivorship. When one of those individuals passes away, it automatically, by operation of law, passes to the survivor. Okay, so that is a simple way that you can pass assets without having or needing a formal probate administration. My issue, or what I talk to clients about, and that's why this beneficiary question is so important, is who's receiving these assets in the event something happens to both of you. Are we dealing with a situation where minor children are involved? Are we dealing with a situation where we have certain beneficiaries who are not great at managing assets? If something happens to both of you, both joint tenants or both husband and wife, community property with right of survivorship, that asset then will be subject to a formal probate administration. So it would be a good situation to move those assets into a trust in order to prevent any unknown or unforeseen situations where something happens to both of you. You can also set up a pay on death or transfer on death account with many financial institutions. And so what those are is, it's a contract where you are essentially, similar to your retirement assets or your life insurance assets, you are confirming that certain people are going to be receiving that account automatically at your death. They do need to provide a death certificate and fill out forms, but it is an automatic transfer, thereby avoiding the need for a formal probate administration. I have one client in particular who he has a lot of retirement assets and a lot of financial assets that he's already instituted a transfer on death contract with. And so his estate plan actually is very simple. He still has a trust in place because he has real property involved, but a bulk of his estate is passing outside of a probate administration, also outside of the trust. So it will depend on what types of assets the individual has. Also, here in California, you can avoid a formal probate administration in our court system by using a small estate affidavit. So here in California, if an individual's assets not going based on a beneficiary designation, not subject to joint tenancy, not in a trust. So really just assets in that individual's name. If those cumulative assets are under $166,250, then those assets can be passed through a very simple affidavit. You have to wait 40 days in order to submit that affidavit. So there is a bit of a timing lapse, or gap, but not a huge one. But you can pass those assets outside of a formal probate administration. So I do have certain clients who have a trust set up and they're moving assets over to that trust, but they also have a car or a checking account. And that car and that checking account, they don't want to take the trouble to transfer into the trust. Cars are depreciating assets. As soon as you drive them off the lot, they are not increasing in value, they are depreciating. A checking account, oftentimes checking accounts are used for day-to-day living expenses. You really are not looking to grow those assets. Those types of assets we will keep outside of the trust, but talk to clients about having a will in place and then using that small estate affidavit because they're under that $166,250 threshold. And it's a wacky number, I apologize. It used to be $150,000 under the probate code, and then they decided to do an adjustment for inflation. So it's kind of a bizarre number, but you can also pass assets outside of the trust based on an affidavit. Okay, so let's move to the next slide. All right, so I've now gone over an overview of what is a trust, some of the key terms associated with the trust, the difference between a trust and a will, and then also other types of assets that can pass outside of the trust where you also avoid a formal probate administration. But my client says, I still need a trust in place for a variety of different reasons. So I've included on this slide just some general issues to consider whenever creating a trust. And so when I meet with clients, I talk about trust, I talk about their assets, and then I talk about these kind of 5 main specific topics having to do with a trust plan. Obviously, the first question is something, you've passed away. Now, who's going to receive your assets? Okay. This can be a very simple question to answer. This can be a very complicated question to answer. Are you married? Do you have children? Do you not have either and you want the assets to go to some other individual? Do you want to benefit charity? Do you have pets? So I brought up Leona Helmsley earlier. California is one of those states that does allow you to set up a trust for a pet. So you can include your pets as a beneficiary under your trust. There are certain requirements that you need to meet. So who is going to be receiving your assets? If you are married, how are the assets going to be distributed to your surviving spouse? Is it going to be a simple outright distribution? Is it going to be held in trust for the surviving spouse's benefit? If it's held in trust for the surviving spouse's benefit, who's the trustee? So who's going to be the person making the decisions as far as investments and distributions? And what are those distribution provisions? This question can become very involved. I've given presentations in the past on blended families, and anytime you have a second, third marriage with children from a prior marriage, you need to be very sensitive to this question of how and when surviving spouse from another marriage is receiving the assets. Also, do you have separate property or is everything community property? That is a big part of the question as far as how assets are going to be distributed. What about beneficiaries other than your spouse? Is it an outright distribution to that beneficiary? Is it better to hold it in trust for that beneficiary's benefit? Are you going to distribute it to the beneficiary at some future age or ages? Are you going to have it held in trust for the beneficiary's lifetime benefit? Who's going to be managing those assets for that beneficiary? And what are those distribution provisions? You can also have charities involved in your estate plan. So obviously we're here with the Library Foundation that wonderfully sponsored this program. So do we want to include charities in our plan as well? This is an area where I spend a lot of time talking to clients about what their wishes are, what their legacy plan is as far as the charity goes. Kimberly mentioned earlier about plan giving and how that's so important to the library and other charities out there. I can put provisions in place, but it is really critical to also have a discussion with that charity as far as what is the best need or best way to make sure that that gift in your trust is going to be the most useful for the charity and also fulfill your estate planning goals. They go hand in hand, and I will say oftentimes the charity is not approached until potentially the person has passed away. And so I always recommend to clients, whenever they're thinking about charitable giving, to have a conversation with the charity, make sure the language that I'm including in the trust works for the client as well as for the charity, and that gift will be fulfilled. And I was talking to Natalie a few weeks ago about a specific gift, and sometimes based on the wording is ambiguous, or the wording is such that times have just changed or things are different in this current situation, and it's very difficult for the charity to effectuate what that gift is or what that plan giving goal was. And so having a conversation with the charity is really important. Also, for individuals, whenever we're talking about distribution provisions, we're very sensitive to what are those distribution provisions going to be. Is it going to be for their health, their education, their maintenance, and their support? Is it going to be only for extraordinary or emergency sort of situations where their other assets are really being used first, and then this is just kind of a safety net for them? Is it going to be distributed at ages or based on certain life events that they've met? They've completed their undergraduate degree and they're going to get a certain amount from their trust or a percentage from their trust. All of that can get fleshed out in this trust document. I also have some clients who say, I have a 3-year-old who, I don't know, she seems like she's doing really well, but she's 3. I don't really know what the future is going to hold. I'd like things to be flexible. So how do we achieve that? We're going to include pretty general provisions in the trust, but I like giving clients the ability to write a letter of wishes or letter of instructions, where in their own words, sometimes in their own handwriting, they're confirming to the trustee, the one who's managing the assets and distributing the assets, how and when is my child going to receive those assets? And it's more informal. So you're really just giving guidance to the trustee. Oftentimes clients get very, they're taken aback with all of the legalese, and it's a legal document and the legal terminology. This is a wonderful way for clients to put in their own words what they believe is an appropriate distribution, let's say under the example of maintenance and support. Those are very broad terms. They're broad on purpose, but this will allow you as the client to tailor what that's going to look like over time. It also gives you the ability to change that over time without having to call me to make a formal amendment to your trust. But it is precatory. It's more suggestions. It's not a requirement. But I will say, especially for trusts that are going to be existing for the lifetime of a beneficiary, it's a really great way to continue to look at the situation, update the document informally. And again, it's in your words. I think there's an amazing piece of receiving a writing or a letter from a loved one in their own words saying, this is how I would like you to use these funds. And so I do include that or incorporate that a lot in my trust documents when talking about beneficiaries and how and when beneficiaries are going to receive the assets. We can also look at whether or not there are certain issues associated with the beneficiary. Are there substance abuse issues? Are there creditor issues? Are they married and we're concerned about potential assets going to the spouse in a bad divorce or a contentious divorce? Do the beneficiaries have children or heirs? How are their assets going to be distributed in the event they die before they're receiving the assets? So all of these can be worked out in a trust structure much more comprehensively than like a beneficiary designation, for example, or a transfer on death situation. So that's why at the beginning of my presentation, I did emphasize that it doesn't really matter too much the size of your estate, the fair market value. It really depends on the type of assets we're talking about and your beneficiaries. If you have a beneficiary who is not good with managing money, that is the sort of situation where we want to build in provisions as far as how and when that beneficiary is going to receive the assets and who's going to be managing those assets for that beneficiary. And then finally, and along those same lines, is who is going to be your trustee? So as I mentioned at the beginning, when you create a California Living Trust, it tends to be you who's also the trustee. You continue to manage the assets, but we're looking at who is going to be stepping in the event you were to become incapacitated. So managing the assets for your benefit. Also, who is going to be managing the assets for your future beneficiaries? They have substance abuse problems, creditor issues, spendthrift issues, or they're just young and not at a proper age to manage assets. Also, when you die, there's a period of administration that can be relatively complicated and involved. What are your assets? What are your debts, expenses, and taxes? And what documents do you have in place confirming how your assets are going to be distributed? This would be the role of a trustee as well, potentially, and this is commonly referred to as a post-mortem administration, who is dealing with your administration now that you've passed away before the assets are distributed out. I've also given presentations in the past about acting as a trustee, and it's a job, and it's a job that includes a lot of fiduciary duties and obligations, as well as liability. And so thinking about who's going to fill that trustee role is a critical part of your estate plan and really goes hand in hand with how and when your beneficiaries are going to receive the assets. Okay, then who on the other hand is going to be managing and distributing those assets for that beneficiary? There's typically 3 different types of trustee classifications that I'll see. One is an individual. It's a family member, it's a friend, it's a trusted advisor who you select as trustee. You can also work with a bank or a financial institution that has a trust company that's allowed to do business here in California. Obviously, with a corporate trustee, you're dealing with an institution that already has procedures in place. They have a team in place who can deal with all the varying aspects of the administration, the beneficiary distributions, the tax filings. So they're equipped to deal with all that. They also have a fee structure in place, so you need to be comfortable with what that fee structure is and whether or not your estate is appropriate to have a corporate or institutional trustee involved. The third type of trustee that's becoming more and more popular these days is a private or a professional fiduciary. And so those people are essentially individuals who have decided to make it their career to act as a fiduciary for individuals. I will say I've worked with a handful of excellent professional or private fiduciaries here in town. They're kind of the perfect blend right in the middle of having a family member and a corporate trustee. They're obviously insured, they have a background that makes them appropriate to act as a private fiduciary, and they have a fee structure, but the fee structure is a little bit more workable because they're an individual. The biggest thing I will say for them is they are individuals. So they're mortal. And so you want to really talk to them about what their succession plan is if you list them. But I do find that they're a nice alternative for clients who really don't have the perfect family member, but really don't want to go the corporate trustee route. And so that's a great option here in California. All right, so that is it. I think now we're potentially switching over to some questions that I will field from Natalie.
Great. Thank you so much, Jennifer. That was excellent information. I hope everybody finds it very helpful. We have a few questions that have come up, and the questions have caused me to think of more questions. So we can talk a little bit about that. First one is a really good question. It's very practical. How often should I review my trust, or should one review their trust?
All right, so that is a great question. I will say for the most part, we recommend that clients review their estate plan every 2 to 5 years, somewhere in that time frame. And then anytime there's a major life change. Major life changes would include a birth, a death, a marriage, major change in your asset situation, as well as on the tax side. So I will say on, as an estate planning attorney, I will work to update clients when we have major tax changes. Right now is a perfect example of being in a state of flux as far as potential tax changes. So we will update you then, but that's a great time as well to kind of look at your estate plan as well.
Yeah, that sort of touches on one of the questions that came in a little bit later about the type of changes in one's life, whether it's a marriage, a divorce, things that happen that could trigger a need to take a look at your trust. And I'm kind of curious, when that does happen, what's the process? Do we have to throw away the old trust or start new, or how's that handled?
All right, so it'll depend. That's a very typical attorney response. So if I'm working with a client, and I have had this exact situation where I worked with them when they were single, they've now reached out to me. They had a separate property trust in place that worked perfectly for them. They've now reached out to me and said, "Hey, Jennifer, I'm married and I have a new baby. What do I do?" And so similar to what I talked about previously is we sit down and we say, okay, what are your assets now? We did this 5 years ago. What are your assets now? Does it make sense to create a joint trust with you and your new spouse and get rid of or revoke that separate property trust? Does it make sense to keep that separate property trust and still create a joint trust? Does it make sense to just have 2 separate trusts? So it's a whole analysis of what the assets are and then what the client's goals are. So, but that does happen with a lot of frequency. It also happens on the other side where I'm working with spouses and they're getting divorced. And now in that scenario, as long as they're comfortable with me working with both of them, it is unwinding that estate plan and talking about what a new estate plan will look like. So, but yeah, we walk through that with clients a lot.
And for smaller things, maybe someone didn't have a charity included before and now they want to, is an amendment ever appropriate, or?
No, definitely. So I will say for clients of mine where I've set up the document, and if it's simply switching out trustees, I would say adding gifts to charity or changing specific gift amounts, at what age or ages my children are receiving the assets or my beneficiaries, and who are my fiduciaries. Those are the most frequently changed provisions. So if I've already created the documents for them, that's a very simple change and may be appropriate to just have a simple amendment. I will say California is very particular about making sure all beneficiaries are aware of any changes to a document once that document becomes irrevocable. So I have had clients who I've done a trust for them and they're changing a specific gift, either increasing it, decreasing it, removing the beneficiary. even though that's a simple change through an amendment, that would be the sort of scenario where I'd probably still recommend a restatement, because then you're starting with a new, fresh document, and the former beneficiary or the beneficiary where the gift has changed is not seeing that change. So it'll depend on the type of change we're talking about and whether or not I prepared the document in the first place.
Great. And I'm going to go a little out of order here just because I think this kind of relates, is should I discuss the provisions of my trust with my beneficiaries? You kind of touched on this with the charities and making sure it's a situation that the charity has very good understanding of what someone's intentions are. But what about kids or other people who might be one of your beneficiaries? Should you let them know now, or should you wait on that? What do you think?
No, so I'm going to give you my personal opinion on that. And this has come from many years as a practicing attorney. These documents are going to change, and they are revocable and amendable. And so I always caution clients about providing copies of documents to beneficiaries, because that's potentially going to change. Even providing them to successor trustees, people become sensitive, potentially when there are changes to documents. However, I love the idea of introducing particularly the next generation, so children, to terms, the concept generally, what's potentially going to happen when I die or when your dad dies, and how the assets are going to be distributed, as opposed to receiving full copies of the trust. Whenever I do estate plans for clients, I put together a flow chart. I think those flow charts are great tools for the next generation or successor trustees to look at. Doesn't detail assets or dollar amounts, but it gives everyone an introduction to what's going to be happening and the process. So it really kind of depends on where the individual is in life as well, and who those beneficiaries are. But you have to be sensitive to providing documents to someone, and then if you change it, then now what do you need to do to let them know about that?
Be awkward, right?
Yeah, yes. Over Thanksgiving dinner, that may create some conversation. So
sure. And you did speak extensively about selection of your successor trustee. And it also got me thinking, in the question here is, what if I don't know anyone comfortable serving in that role? And I'm also kind of curious about your thoughts on co-trustees. If you want the professional, but you also want someone from the family involved, what's your experience with that been like?
Okay. So if the person doesn't have the right individual to fill that role, that's when we talk about the corporate trustee, or again, the professional or private fiduciary. I have met with clients in years past where they've asked me for referrals or recommendations for private or professional fiduciaries, and I'll provide that. So that is a good kind of option if you don't have that right special person in your life to act. Also, sometimes it's just nice to have someone neutral involved. So maybe you do have family members who are, financially or fiscally responsible, but you just don't want them involved in the trustee role. That would be a scenario where I would talk to them about a corporate trustee or a private or professional fiduciary. Co-trusteeships are, again, something I'll talk to clients about, and it'll depend on who those co-trustees are. I love the idea of having a corporate or a neutral person as well as a family member, and it's just whether or not that's going to be a co-trustee role. We could have a trust protector role. We could have an advisory role. So there's kind of different levels, and that will really depend on the client and kind of what they're looking to achieve. And it depends on the corporate trustee too, or the professional fiduciary, and whether or not they're comfortable with a co-trusteeship. Because what we don't want is the administration to be stalled or stopped because two or multiple trustees are not agreeing. So what are the options there? The option there is one or two of them resign That does not frequently happen. Or you go to court and you have to get it kind of worked out, and no one wants that. So multiple trustees can be problematic, administratively a little bit more difficult. I had a co-trusteeship where it was 3 siblings by majority vote. And then after my client died, I found out they hate each other, all 3 of them. And so that was a terrible trust administration experience. They could not agree on anything. They could not decide, and everything got stalled. So, I spent a lot of time talking to the clients about the situation.
Yes. So we're not, depending on how long this next question takes, we have time for 1, maybe 2 more questions. I see we've got several, so we'll do our best to get through it. Question about providing equally for children and how to make sure you're doing that. And then maybe potentially situations where you might not want to provide equally for your children. You know, I've seen situations where 2 assets that have a similar fair market value are given to children, but they're taxed differently, and the result is that you have not actually treated your children equally. So can you talk a little bit about that?
Sure. So I think oftentimes when I meet with parents, there is a desire to treat children equally. I always try and talk to clients about the fact that you don't have to. There's an expectation that you're going to be treated equally, but it's not a requirement. I do have a lot of clients who talk to me about, I've given certain children something already, and I want to make up for it on the back end with my other children, because at the end of the day, I want it as close to equal as I can get. So how do I deal with that? So I will do a lot of work on the trust side with clients to make sure there are provisions in place where those gifts that were made during life are actually treated as advancements on their eventual inheritance. So we'll include those provisions in the actual document. Anytime a client of mine says, I want everything to be divided between my 3 children, but I want child X to get this asset, child Y to get this asset, and child Z to get that asset, that's administratively impractical sometimes. And so I will talk to clients a lot about what that means, kind of exactly what you said, Natalie. What are the maintenance costs? What are the fees associated with maintaining this asset? What are the property taxes? Do they even want this asset? Will you have that asset when you die? So all of these things we work through with clients. I frankly don't like specific gifts of assets. And I talk to clients a lot about how your assets are going to be changing. I talk to clients a lot about, I want to force the sale of this asset when I die too. We just don't know what the situation is going to be. Again, COVID was a perfect example of sometimes things go wacky or haywire and they're unpredictable, and you want a flexible plan in place. At the end of the day though, Natalie, people may say, I don't care, Jennifer. Thank you for the advice. I still want to proceed with the plan as set forth. And again, my job is to provide recommendations, provide kind of the devil's advocate. Have you thought about this or that? But at the end of the day, it's the client's estate plan.
Absolutely. We'll take a couple more, a little bit more. We are coming close to the end of our allotted time. One question here. Does California provide any asset protection trust, or is the only option to do an irrevocable trust?
Okay. Yeah, so that's a great question. California is not, it's not a great jurisdiction for creditor protection trusts. There are certain states here in the US that are better for it. Nevada is a great example, Delaware, Wyoming. Those are states that allow, let's say, for example, myself to set up a trust that I can still be the beneficiary of, but I get some insulation from creditors. California is not one of those states. So yes, you can create an irrevocable trust, but you cannot be the beneficiary of that trust any longer. So you need to be comfortable with giving away that asset. I will say another alternative that I'll talk to clients about from an asset protection standpoint is insurance. So buying insurance that will hopefully protect you as much as you can guess from an unforeseen sort of creditor issue. Also, depending on the type of asset, you have an investment property, whether or not it makes sense to hold it in an entity like a limited liability company and get at least some protection or insulation of your other assets from something happening at that asset or to that asset. But yeah, California is not one of those kind of self-settled trust sort of jurisdictions. We make it hard. California is always problematic. So
Keeps it interesting.
Yeah. Keeps me employed. So
There we go. Let's do one more. Does the trust and every change need to be recorded? And in this person's situation, they say my 5 largest financial investments all changed in the last couple of years. For example, such as investment funds assumed new ownership or name that I had no choice in. And they also want to make sure that thank you and thanks for the informative presentation.
Okay, excellent. So as your assets, so living trusts are contemplated to hold different types of assets. So we're going to set it up on the front end and we're going to transfer assets into that trust. Those are going to change. You're going to sell assets, you're going to create new assets. I will say though, title is critical. So if, for example, you create a California Living Trust, you hold an investment account through Schwab in it, and then you get rid of that investment account through Schwab and you create an investment account with Fidelity, and it's just in your name and doesn't reference your trust. That's the sort of asset that is not going to be controlled potentially by the trust until after potentially a formal probate administration. So anytime you put a trust in place, we're also going to put a will in place that's going to capture any assets that are just in your individual name. It's just that process that you need to implement in order to get the asset transferred over. But if you get an account at Fidelity 10 years after you create your trust, as long as you title it in the name of the trust, that's going to be controlled by the trust.
Great. Well, Jennifer, thank you so much for this wonderful presentation, all the information that you provided and handling all of these questions. I hope that all of our guests found this helpful and informative. And will stick with us and come back the next time we have our next estate planning webinar. With that, I will call back up my colleague, Kimberly Mueller, and ask her to take things from here.
Thanks, Natalie. And thank you to our guests for all of your meaningful questions. If you didn't get your question answered, please feel free to contact Jennifer, Natalie, or me. Our contact information will be up on the screen shortly. We'll email it to you as well. And we would love to get your input on this webinar. Please click on the link in the chat to take the survey. We'll also include the survey in our follow-up email. Jennifer, would you like to share some closing comments?
Sure. So again, thank you for the opportunity to present to all of you today. My contact information is up on the screen. You can also just search my name on the internet, and please feel free to reach out if you have questions that did not get answered during the presentation. And I will share just one quick personal note, since we're here with the Library Foundation. I have 2 daughters, a 13-year-old and a 9-year-old. And I remember vividly the first time I took my 13-year-old to a library here in San Diego. And she walked in, I don't even know how, maybe like 3rd grade. She was just starting to read. She walks in and she's like, I don't understand. Like, she was so amazed with the concept that there was a building filled with books that she could take for free. And as long as she returned it, it was good and she could keep using it. And she was just so amazed. And it was so sweet to see it from her eyes. And the funniest thing was she was like, when was this invented? This is like the most amazing invention ever. And I was like, well, actually, Madeline, libraries have been around forever. And so, technology is changing, our world is changing so much, but I will say as the parent of 2 children, they are still so engaged with the library. They love going to the library, and they just think it's the neatest thing. And so I just want to thank all of you for all of the amazing work that you do in helping keep our library system in place. And our youth is still crazy engaged with it and excited about libraries. So thank you for all that you do.
Thank you, Jennifer, and thank you to your daughters as well. I want to thank our wonderful speaker, Jennifer McGibbons. We deeply appreciate how generous you've been with your time and expertise. And to our guests, I'm so grateful to you. I hope our conversation has been beneficial to you. Please be on the lookout in our emails and e-newsletters for future estate planning webinars and other talks throughout the year. If you'd like more information on plan giving, please contact Natalie or me, as well as your professional advisors. I hope to see you soon at the library. Thank you for joining us.